And take, for instance, a case where you have a contract with Nigeria, or in a recent case of mine in Abu Dhabi, I saw a client who was very happy to have negotiated a contract. I resisted Abu Dhabi law. I don't know Abu Dhabi law. We have no lawyer who could say that the contract is valid. I am a great negotiator. I accepted, I secure New York law with an arbitration in Abu Dhabi. So New York law with an arbitration in Abu Dhabi, frankly, is worth zero, because the arbitrators are going to render an award in Abu Dhabi. Then it's accepted that you can have recourse, an action to set aside in Abu Dhabi, in the place of arbitration, and your award, of course, is going to be set aside if you lose. If you win, if the state, or it's normally state entities or whatever, or even a local party would be a local sheikh, and it would be the owner or the client or whatever, and if they lose, they would get the award annulled. On the other hand, Abu Dhabi law, frankly, is a civil law code.
It's based on Egyptian law.
It's based on Egyptian law. Egyptian law is based on French law, so it's really 95% French law, a little bit of Sharia. You would have certain rules on interest, which are different. You may have a rule on change on circumstances, imprévision, which was added in Egyptian law and then copied in the Arab world. But you would have a few different things. But frankly, if you have an arbitration in Geneva, the Swiss arbitrator applying Abu Dhabi law will make sense of it, and you don't have to worry about that. They'll probably enforce the contract. Whereas if you have, say, a law you're very comfortable with in Abu Dhabi, applied by an Egyptian lawyer as the chair, you get a lot of uncertainty. Why do I say a Swiss lawyer and an Egyptian lawyer in one case or in the other? Well, because in practice, the venue of the arbitration, the seat of the arbitration, has an influence on the chair. Assume it's the ICC which makes the appointment. Assume it's ICC arbitration. They will first say, I don't want a national of any party, so no American, no Abu Dhabi. Then I want someone familiar with the applicable law. So if it's Abu Dhabi, they would say, well, it's any civil law lawyer,
right?
So a Swiss would do.
Yeah.
And if I see that the venue is Switzerland, that's sort of an indication. It's not mandatory by any means, but ICC arbitration in Geneva, Abu Dhabi law applicable. I need a civil lawyer, and I need a civil lawyer from a neutral country. Something convenient to fly to or to go to the place of arbitration. Why not a Swiss? Because it's going to take place in Switzerland anyway, the hearings. So I would have a Swiss applying Abu Dhabi law. That's very safe. On the other hand, if the seat is Abu Dhabi, ICC would say, look, it's Abu Dhabi, it may be New York law, but in that case I may want a New York, someone who is familiar with New York law, so I need a civil law, I need a common law lawyer, but the seat is in Abu Dhabi. Maybe it's an indication that another a citizen from another Arab country would be in order. So the odds to have an arbitrator from a different legal system would be greater. Of course, in my example, if it's New York law, you may have a common law lawyer flying to Abu Dhabi, so you may end up with a Brit sitting in Abu Dhabi, which would be good enough in terms of the arbitration itself, but of course the award, even if you get a good award, you may discount it heavily to avoid the annulment risks at the place of arbitration.
I got to tell you, I actually have experience with the litigation in the courts of Abu Dhabi that we won. We have a 1.6 million. No, and it was. If we want to talk about efficiency, the proceedings went very quickly. It was about, I think, 15 months from the beginning. It was a technical dispute. over a large piece of prefabricated equipment that we built specifically for a project that then the buyer did not take possession of and refused to take delivery just because they didn't have the funds. But they have assets, so we began a litigation in the court of Abu Dhabi, had a proceeding with an expertise, a court-appointed expert who assessed the value of the equipment, and this decision in our favor, very fast from beginning to end.
But was it against the government?
It was against a refinery in the Emirates, in another one of the Emirates, not the Abu Dhabi Emirates. The problem that we've had is enforcing the decision. It's enforcement proceedings. I think that there's actually a problem that we've seen in that a recalcitrant party can, even if you get a binding, solid, no way to attack, whether it's an arbitration award or judicial assistance. I mean, we went through all the appeal process too. We got a binding, first-degree court decision, appeal all the way up, up and down through all the appeal process. And we've been in enforcement proceedings for the past 4 years. And, again, in the enforcement stage, you have an expert appointed again to reassess what was done before. I think there may be, at some point, sometimes you may just have to say you have limited recourse, even if you can get an effective decision. And that's
true. But if you are facing the risk of the award being annulled by the local courts, it means a huge discount in the negotiation.
Yeah, right.
That's why I often say that the arbitration agreement has a value which you can quantify. Certainly you can at the end of the day. If you have your arbitration in the country of your opponent and it's a public entity, you know that the courts are not all that independent. You may win, you may have a great claim for 100 million, but if you have an award for 100 million, you know that it may be set aside, so maybe you want to settle for 50. In that case, the arbitration place is worth 50 or 40 because you will have a discount anywhere for settlement, but it may be just a 10% discount and not a 50% discount.
So a lot of value, place of arbitration.
There's a lot of value in the arbitration agreement itself and the place of arbitration.
Thank you so much.
Well, thank you. It's extremely important because arbitration is only as good as the arbitration agreement which you have negotiated.
Yeah, I think we learned a lot. This is terrific.
You've been listening to International Dispute Negotiation. This podcast is presented by the International Institute for Conflict Prevention and Resolution, CPR. CPR is a membership-based nonprofit organization that promotes excellence and innovation in public and private dispute resolution, providing an international resource for the avoidance, management, and resolution of business disputes. For further information about CPR, or to download archived versions of this podcast, go to www.cpradr.org. Questions about this podcast or the issues discussed can be addressed to idn@cpradr.org. The music of Note Noir is used with permission.